specialises in work with court-involved children and families. She provides parenting coordination, consultation, treatment, and intervention services to children and families involved with the courts, as well as forensic expert and consultation services to attorneys and training consultation services to mental health professionals. Specialty areas include assessment of child abuse allegations, child interviewing, and specialised interventions for complex child custody cases, including those involving children with special needs. Dr. Greenberg has written and presented extensively on a variety of issues related to child custody, child abuse, professional ethics, interviewing children, and the professional practice of forensic psychology in child custody and child protection cases. She enjoys an international reputation for her expertise on treatment of court-involved children and families, early intervention, parenting coordination, and other specialised services. And she teaches frequently in the States and in several international venues. She and her co-authors were honoured with the AFCC Maya Elkins Award for their model on early intervention with children and families. She served as a reporter and member of the Association of Family and Conciliation Courts Task Force on Court-Involved Therapists and has been appointed co-chair of the task to update these guidelines. And I understand that this task force has now been constituted, but Lynn can tell you more about that. Lynn has been honoured by both the American Psychological Association and the Association of Family and Conciliation Courts for her work, including the 220 Science-Based Practice Award. She is one of a select group of authors invited to contribute to the APA Handbook of Family Psychology. She's a leading editor of evidence-informed interventions for court-involved children and families. In 2024, Dr. Greenberg was awarded the Joseph Duran Award for Outstanding Services to Children by the Association of Family and Conciliation Courts, California chapter. Lynn, it's a wonderful CV, and we are so lucky to have you here today. I'm going to invite you just to say hello to everyone, and when you're ready, I'll start sharing your slides that I have on my screen ready to go.
Well, thank you, everyone. Thank you, everyone. I'm honored to be here. Let's go ahead and put the slides up, and we can get started. I want to thank Glennis and everyone else here who apparently you're working with a new system, which if it was me, I would be completely unable to cope. So I'm very impressed, Glennis, that you were able to put this all together. What I'm going to be talking about here today is social science, a legal or social science concept. And this was derived from, let's go to the next slide. You've already told me who's here today, so we can go to 2 slides out then, slide 3.
Sorry, I'm just having trouble. Here we go, 2 slides.
So let me let you know something about the handouts real quickly. We were able to get certain articles over to Glennis already. Those are the ones where I'm a co-author. Because I have a legal right to use those. There's another set of them that I believe they'll allow us to use, but we're still seeking permission. That was written for the special issue on evidence-based and evidence-informed services, and was a set of responses to questions that we submitted to judges. One of whom was Justice Thomas Altobelli from Sydney, And so we have sought permission. Any AFCC member would be able to just get them, but I know with the separation, I don't know how many here are still AFCC members. So we requested permission to get that to you. And I'm a member of Pacifica as well, but Pacifica doesn't have family court review. So that's the story with that. We'll get those to you. The reference list that we have goes a bit beyond today's presentation because as I'll be covering things today, you'll see that there are some things that are complex issues that we can only simplify so much. So maybe one of these days we'll do something longer, but right now we wanted you to have the resources. So moving on, the origins and scope of this presentation. This started with the National Family Law Conference in Australia, in Perth last year, in the aftermath of the passage of your new Family Law Act, I think it's called, that's what it's called, but the one that has language in it prioritizing child safety. And that was, as I understand it, a little bit of a change of language, and not all the terms were defined. So what I was told there and by Justice Altobelli is that it's in development as to whether safety just means avoidance of harm or whether safety is being contextualized in a broader way. So they asked me to provide a bit of a social science context to that. And one of those things is whether we're conceiving of safety as just protection from something, or in a more proactive way, safety to be able to do certain things. And we'll move on to the next slide and define those things a little bit. When we're talking about safety from, we're talking in more basic terms about safety from abuse, violence, neglect, the mental illness or substance abuse, severe parental conflict or toxic stress. These are things that can lead to child protection orders in your child protection courts or family courts. The same thing happens here. And those have the definitions of safety that are, there's a lot of overlap in how those are defined. And the additional construct of safety too, which is on the next slide, is whether we're providing safety to children to develop, to resolve emotional issues, to not stay stuck in trauma, to be able to trust their own perceptions and abilities when they're getting input from all over the place, to engage in healthy relationships, and to recover from traumatic events. And those of you who do treatment or single expert work, provide services to treatment, know that in many cases, protecting a child, removing the source of the original trauma from the child's life is not necessarily sufficient to help the child develop in a healthy way. We need broader concepts of how do we help children to become healthy, and what do we need to think about in order to do that, and what kinds of orders do we need, what kinds of services do we need, and how do we get to a broader definition of what safety means. If I meant to mention that for, you can go to the next slide. I meant to mention that we want to have some interaction going. We were figuring out how to do that with your system, so people can submit questions by chat, and our lovely moderators are going to let me know when we have questions that need to be answered. There are going to be certain sets of slides where I'm going to touch on some controversial issues. So I'll break after I do that to ask for questions. But since one of the critical issues when we deal with children's safety, one of the critical issues is how do we define safety? And what's the breadth of our definition of safety? And are we considering all the possibilities? So you can expect me to touch on different definitions of some terminology that's been in the press lately. And I'll just ask you to wait as I get through that set of slides so that you know what I'm actually saying as opposed to what might appear on one quote from a slide. So the terrain that we're all operating in is more mental health crises, vulnerabilities among the family law involved population. In Australia, I know that my colleagues and friends there, as I've been there, tell me that you have some challenging resources. To me, if there was legal aid for families in the States, I would, have died and gone to heaven. But, we in the States are sort of locked in the opposite of heaven, at least for another year and a half. So I'm not, expecting that much improvement where that's concerned. And I know Australia has a certain level of resources that's beyond what we have here, but that there's also more people who need them than the resources that you have, correct? So some of what I'll talk about is going to depend on the resources that are available, and I know that. There are a lot of impediments to effective service delivery, from conflict, from poor collaboration, from polarized discussion everywhere between the parents, also in professional discourse, from disputed and sometimes distorted language and findings. I will talk about that a little bit. And from what I understand from my colleagues there, judicial interpretations of the new Family Law Act are also developing. There are a few appellate cases on it. Their judges are finding their way, as everyone else is. But I will tell you, I am not a lawyer, and I'm certainly not a lawyer there. So if there are things that I say that aren't accurate as to Australian law, I hope we'll get some chats about that. But know that what I can contribute here are social science interpretations and input from psychological practice. I'm not pretending to be an expert in Australian family law. So let's go to the next one. So I've been always surprised that in listserv discussions and professional discourse, we correct and clarify terminology. And more than a few of our colleagues will say, so what's the difference? We all know what we mean, right? And as I'll show you as we move through this, we don't all know what we mean. When we use fuzzy language, people can walk away thinking that there's agreement where there isn't agreement, or that they can express things as if there's agreement when there isn't agreement. So showing our work really matters. We need to define our terms. We need to not assume that everybody knows what we're talking about, because it can make a huge difference in outcomes for children and families. Next. Next, please.
Just stuck.
Can we have the next slide, please?
Next slide.
It's being persnickety with you. Okay. So if words matter, the way that we use language, the language we choose to use, how do we? I'm going to issue a involvement challenge here to go on to chat as I go through this slide and type in a word or phrase that will reliably blow up your case. If somebody uses this word or phrase in a pleading, in a court argument, in anything that's going to come to the attention of the court, that your case will reliably blow up. The example I use is personality disorder, but I'm sure that you can all think of a few more. So I'm going to say, throw some into chat, and Glynis, maybe you'll be able to tell me what some of the ones are. Because there we go. Thank you, Kaylee. My assistant Kaylee is here. So these are, what are the things trigger I saw here? What else? What are the words and phrases that if somebody uses them in a case, the case suddenly becomes about nothing but that. So if that doesn't happen when somebody says borderline in one of your cases, sexual offender, there you go. That's one. Even in some places in the US, depending on what the presumptions are, special needs can come up. Autistic, ADHD, anything that someone's going to use to say we can't have joint custody, alienation or alignment. I'll get to that one. So the language we use reflects our views of family problems. It reflects how we approach assessment, and sometimes it affects the range and the types of solutions we consider. But that has to be balanced against the fact that if someone listens to the first half of your sentence and then goes off on their own definition, that doesn't necessarily lead to accurate understanding either. So as more of this breaks into the popular press, as we see more and more extreme solutions proposed, and what children's reactions are to the solutions that get proposed, sometimes we are seeing triggering, or we are seeing just assumptions about what we actually mean when we say something. I mean, sometimes we're talking to a cast of thousands. We're talking to mom and every website she visits, and the online discussion groups, and the same with dad. And then we don't know who we're talking to with the child. Give me 1 second, please. My apologies. All right, my asthma kicked up a little bit. You gonna okay, so let's move on. Any other suggestions of words that they blow up your case when you hear it? If you think of any, throw them in there. Let's move to the next slide. Sorry for the copy kit. So here are some of the critical terms that we encounter. And there's a lot of moving definitions of some of those terms. There is, in some states, legislative language outlawing coercive control. And now we have advocates from the DV community here, or some parts of it, who want all those laws repealed because they feel like it's being turned in the direction of favoring the estranged parent. The more specific, obviously, the more specific we are in our language, the less likely inaccuracies are to result. But the distortion that's happened in the literature here is that, and we're more in political advocacy, is that people are saying it's either alienation or it's domestic violence. And back when we all took domestic violence training, didn't we all learn that sometimes, often, it's the domestic violence offender who is alienating the child from the other parent? That kind of behavior often comes from offenders. Well, if we split them into two camps, we can have some really distorted results legislatively and clinically. And I have seen cases, I'll talk to you about legislative developments in a few minutes, but I've seen cases in which, especially in child protection court, when there was violence in both directions. Somebody was undermining a parent-child relationship, someone was engaged in violence, someone was engaged in neglect, both sides were threatening the child, pets got killed. And some of these things have happened because of tunnel vision, of not looking in every direction. So a new phrase that got invented here was alienation theorists. It was invented 4 or 5 years ago. I'm still trying to find out what it means. No one seems to be able to give me a definition. But once that language is used to describe someone, it seems to be perceived as someone who doesn't care about child abuse. Not being an alienation theorist, I don't really know, but it seems that no one else does either. So this is one of these situations where we want to ask people, what do they mean when they say something? Reunification is another word that we have to know how it's defined. Here in California, our Family Law Act doesn't allow for reunification per se, but it does allow for family therapy. Whereas in the child protection courts, reunifying parent-child relationships is an expectation of the legal process. So depending on where the client is, you can get all sorts of definitions of that term. I use the term family therapy for what it is I do, because I think that all of these problems are family systems issues, and that even when there was a clear family violence offender, that doesn't mean that everybody else in the family doesn't need to heal. Trauma is another interesting word that has suffered from what we call concept creep. It seems to be expanded or contracted. When I started practicing in dependency court, trauma was a label that we sort of stuck on a situation, and we sent the kid out into the world with the identity of a victim. And I don't think we did a lot of good if we didn't do any more than that. Now, of course, there are so many evidence-based ways to treat trauma that the impacts of trauma don't have to be permanent. So we need to know that. And we'll talk about toxic stress in a minute. Let's move forward. Can we go to the next one, please? So you all can, aren't we on dangers of extremes and assumptions? No? Okay. Okay, that might be, I'm good? Okay. So I'm not going to read every slide to you. I wanted to set out these concepts. I think you're all professionals, you can all read, and we'll make sure these slides are made available to you. I'm just going to point out the fact that when we get into extremist positions, somebody loses. The child loses, the parent loses, science loses. We lose our focus on children's developmental needs. Yeah. We create confusion for the court. Here in the States, we've had legislation that was so awful, they didn't know what they were doing. They tried to outlaw any treatment to which a child objects. And we had to explain to them that that would have meant that kids would never get treatment for substance abuse.
I logged in just so that when the recording comes up, I can look at it like after.
Hi, sorry, we're getting somebody who doesn't have their mic turned off and we can hear them talking. Just make sure all your mics are off. Thank you.
Thanks so much. Send those chats through. I'm watching. My brilliant assistant Kaylee showed me how I can look at them. So in any event, this law that they tried to pass here, which is known variously by Caden's law or Peaky's law or the destruction of children's mental health law, we would have been, I mean, imagine those of you who are clinicians. Have you ever met a kid with ADD who understood his condition before anybody had worked with them? Have you ever known a kid with substance abuse who was competent to decide if they needed treatment? Or a kid with an eating disorder who can die from that disorder? The distortions got so bad around family law that in California, there was a real risk that they were going to outlaw things that kept children from killing themselves. So it all starts with, and in this case, it ended with the scientists, the social science people, the lawyers, the experts, having some discipline, calming down the affect and saying, this is what this means. That, whatever you're saying, is not what this means. Next slide, please. So I think this one is sort of self-explanatory. If you're a hammer, everything can look like a nail. If you're only looking for one possibility, you're going to miss things. I have had cases with actual family violence go through 3 or 4 people and have nobody notice that the child was autistic. There had been bad parenting. There had been physical restraint of the child. There had been a need for parent education, and the kid was autistic. And so we have to keep our eyes open because we're the only ones who can. Next one. Oh, for a little comic relief, I don't think I need to comment further on this. I think you've all seen it. Next one. Now this one needs some context here. The word uncomfortable, I don't know how much of this is happening in Australia. It's definitely happening in the States. Some of my Australian colleagues who I've worked with there say it also happens there. In order to truly advocate for a child, we need to advocate what they need, not just what they want. So I'm never going to disregard the feelings of this child, but I want to know what they're about too. I want to know what the child's uncomfortable with, what they're worried about, what's making them uncomfortable. Are they worried about the other parent's reaction? Are they afraid of the parent? Do they not know who's going to listen to what they say? Are they missing the parent? And because they're missing the parent, they're uncomfortable dealing with their own feelings. I want to know what that discomfort is about, because I don't want to leave the child thinking forever that they can't do any better than to be living with this discomfort. I look like I'm dead again. Oh, sorry, I started to push my own button. Could we go on to the next one, please? I'm sorry for the vampire parents, everyone. We're trying to figure that out. I don't think I need to comment further on this one, although my Australian colleagues tell me that this is an issue that comes up. I know more about Western Australia than I do about New South Wales. So tell me if I'm getting it wrong. But I understand that for a family therapist to even get access to speak to the child's therapist can be difficult there, and sometimes can be a challenge, and sometimes can be covered with an order. And having the order can allow therapeutic collaboration. I think that's also can be true with the privacy issues in parents therapy. The point I'm making here is that if somebody only hears one perspective, that can result in distortions, and that can really lead to some bad results. So treatment collaboration is important in these cases, but just how we judge information can be as well. Next slide, please. So this is a really important slide. I'm not going to spend time on all of them, but the levels of stress issue is a huge thing that we need to know about. I'm not going to have time to talk about it in great detail today, but I would like to, just highlight for you, thank you so much, the fact that stress is a variable concept. Healthy stresses, like the stress of going to kindergarten after one has been very happy in preschool, is a normal developmental stress. And if we didn't decide that children needed to move to the first grade after being in kindergarten, we would have a generation of children who can't read. And healthy responses to that kind of stress is mastery, as many of you I'm sure know. You master new skills, you master new abilities. The moderate stresses like parental illness, like moderate conflict, divorce, can really cause some problems for kids. And again, the reaction, the healthy mastery of that is support and resolution and resilience. And you have some wonderful programs at Australia that promote those things. And it's a severe toxic stress, chronic severe stress that can lead to really permanent problems in children. I know everyone here is familiar with ACE factors, and we know that when children are subjected to severe and prolonged stress, that can lead to very strong effects in terms of their mental and physical health, even to the point of early death. And so we want to be focusing on, and I'm sure I won't get to everything today, that we want to be focused on what do we do to help children master the skills so that even if their parents are far less than perfect, we can keep them safe, safety again, from enough toxic effects, and arm them with the abilities to cope as they get older. So next one, I'll break for questions in a minute or two. So the next slide, please. Our core issues are here. What abilities do children need to adjust successfully? What circumstances or conditions will help them get there? How is this relevant to my role, to my job? And what realistically can I do? So I urge, if we had half the number of ICLs here that you have there, that's what I would be telling them when I train. They're called Minors Council in California, and they're worth their weight in gold, and we don't have enough of them. And that's why I spent so much time in Australia. Next question, please. So we want to anchor on what we know about all of the issues that are referenced here. We have real science, real research on what can help children with certain symptoms. On your resource list that we sent you, you will see, and I should have mentioned this before, don't try to write down everything that I'm saying. I want you to be able to be free to be here. So you'll have a resource list, you'll have references. All that is going to be, or already is, in the packet of handouts here. So don't worry that you have to be catching all of this. You don't. Not that I'm not brilliant, but we wrote stuff down. There's a website called, and I was kidding about that, effectivechildtherapy.org. It's wonderful. It lists evidence-based approaches to lots of problems that our kids have, which can be adapted to our population. I know that Australia hasn't had as many scientific attacks yet as we've had here, but Kathleen McNamara and I and my brilliant former student, whose name is Sarah Wilkins, wrote an article about appropriate use and abuse of science in family law cases. That one is already in your packet. Toward the beginning is boring and dense and scientific. The latter part provides tools for everyday use, also for lawyers and judges. And so that helps in anchoring what we know. So without further ado, next, please. So what do we know? We know that a child's job, I'm going to be very profound here, a child's job is to grow up healthy and to master developmental tasks along the way, to learn to have relationships, to get along with people, to solve problems constructively, to manage stress. We can't save them from every stress, but we can help them learn to manage it, their physical reactions, everything. And to learn emotional control. Next slide, please. The parent's job, and by extension, when we have really screwed up parents, our job, is to try to create the circumstances and the environment that helps kids achieve these goals. So we have a duplicated slide here. So can you go 2 slides ahead, please? Sorry, this is our bad. Okay, so I mentioned before the dangers of extremes and assumptions. I'm going to, at this point, pause, and before I get into some specific terms and controversies about that, I want to ask if anyone to put into chat any particular questions that you have so far. And and just, Glennis, do you have anyone asking to ask a question yet?
Um,
No,
I
Glennis, we
actually-
don't. Glennis can't
Yes.
see the chat, but I can. Oh, okay. Sorry, we do have a chat now. One of the significant problems in our courts is that report writers almost never particularise research. Motherhood statements and generalisations are made. I operate in both roles. Reports are supposed to be evidence-based. As a barrister, I will often make a point about asking questions about a precise source. Shana, that's I hear you. Did you want to put a particular question in there?
That's a good comment.
It's a good comment.
It's a great comment. And if what you're asking is where to find those precise sources, I got you covered. It's in our handouts. But if you look at our articles, you will see how that's done. I think that the reason I'm not a report writer anymore, I'm a recovering report writer, is how, first of all, I wanted to fix things. I didn't want to just identify problems, but also the reports themselves are exhausting to do. So I think it's perfectly reasonable. And we make this argument in our science-based practice article that you have, that it is perfectly reasonable to ask what somebody is drawing on, and to know what their and what were the limits of the studies they cite, and what they're basing that on. Sometimes it's more than one thing. When we talk about treatments that is effective, we do have to take the research on, say, child depression, or the research on ADHD and the interventions we do with parents, and adapt them to the case that we have in front of us, which may include one family that has both a depressed kid and a kid with ADHD. But lo and behold, if you look at the research on these things, you find that there are many common elements. And it's my belief that we should be able to explain to you in English what the connection is and how we tailored the research to the family. And that article also contains definitions of evidence-based practice, which will help you with that. So I want to move on to an example of where some of these distortions are made. We're all familiar, next slide please, sorry, I didn't ask. We're all familiar with the arguments over, quote, alienation, unquote. And I got and I know that I'm going to ask you guys to wait through the next 4 slides, 5, so that you can get the full context of what I'm saying, and then have at it, chat me whatever you want. I actually saw on the website of a family law firm, and even if I could remember, I wouldn't name it, a website that defined parental alienation according to the people who use that terminology, and then said it was otherwise known as resist-refuse dynamics. And I wanted to tear my hair out, because they are not the same thing. And I want to go through that as an example of what the issues are here, so that hopefully after you leave here, but the greatest success I could have would be for you all to join me in, if somebody blurs these two things, to say, you know what, they're actually not the same thing. So parent alienating behaviors, the new definition Johnson and Sullivan tried to give us, you'll see that it specifically references an observable pattern of negative attitudes and beliefs of the parent. And this was on the website correctly that I saw. You can see that it really is a specific definition of a severe parental undermining dynamic. Next slide, please. Now, resistance refusal dynamics, which is the terminology that I and my former office partner, Linda Doy-Fick, and Judge Robert Schneider used, I will tell you that we should have come up with a better term, because at the same time that we were writing this, Other authors were using resist-refuse dynamics, and they got confused. And we really let go of this term and kind of joined with the people who use parent-child contact problems. But I still want to identify, because it's all over our writing, what we actually said. And what we actually said was, we defined resistance refusal dynamics as a family dynamic in which a child resists or refuses contact with a parent, or demonstrates regressive behavior that either parent associates with parenting transitions, that it may reflect multiple contributing factors, it might be responsive to early intervention, and we specifically extended our model down to very little kids who are so young that you can't accuse anybody of alienating the kid. But there might be a dynamic of anxiety or regression or half a dozen other things going on. And we specifically did not attribute causality. We were looking to fix it, not to blame anybody, unless somebody then demonstrated that they couldn't participate in fixing it. Next slide, please. So at the same time, Gans, Walters, and Friedlander came up with the RRD terminology, which does talk more about unjustified rejection of a parent and basically referred to older kids. We had not spoken to each other. We didn't know that we were creating overlapping terms. But this is again not as severe as alienation, and certainly not as a parental alienation or the syndrome concept, which I don't subscribe to. There's variations here. And then the final term that's being used in more modern cases, next slide, please, is parent-child contact problems, which is, of course, a much more generic term. It really encapsulated what Linda and I have been trying to say all along. We weren't the only ones, but it's a spectrum of dynamics that can result in a child having resistance, having regressive behaviors, having anxiety after or before a parenting transition. It is a huge range that we have to be open-minded to considering, which is the point that Linda and I were trying to make. And had Linda lived, we probably would have refined it more, but we refined it more in terms of the practicalities. So let's go to the next slide. So after all that clarification and all of the hundreds of times that everybody has clarified it, what do we end up with? We end up with listserv discussions in which people use as the subject PAS/PA/RRD/PCCP. It's as though all of these concepts were the same, and people get careless. And so they just put it all out there as one label. And what are the consequences of blurring the distortions? Well, first of all, advocates on there's no such thing as alienation end of the spectrum blur all this stuff together and say that those of us with the more moderate, developmental, open-minded concepts that might rely as much on helping the kid have special toys to take with them as any blame of the parents, that we're all just the same as somebody who denies the reality of domestic violence. And sometimes on the syndrome side, you also have people who have an interest in blurring the distinction. And it results really in massive confusion to judges, massive confusion in professional discourse. A lot of the moderates then leave the discussions because we get frustrated at having distortions come back to us. And I will tell you something I haven't talked about much until recent months. My former office mate, Linda, was killed by a mentally ill family member. And so we have a situation where someone who's no longer alive to defend herself and was killed in a family violence incident, even though it wasn't custody violence, obviously, gets to listen to advocates talk about her as though she didn't care about domestic violence. So anybody who's ever seen an email from me reacting strongly to that, it's an extreme example. But if you look around you in cases that you see, we don't even use terminology, we stick with parent-child contact problems, but you will see lots of people blurring these terms. And it has real consequences, because if you say parent alienation syndrome, or you say sexual offender or violence offender, it introduces that blame dynamic that can blow up a case. Comments, questions? Wishing I would get to another point. Anything, any of you? I can move on because I'm getting to the cartoon part. I'm hearing something fairly, but not clearly. Okay.
I've got Sally Cole, who's one of our ICLs, saying,
Sally, I can see your comment, but I can't hear you. So I'm going to respond to the chat. Okay. So the comment is about that the more family therapy she sees, the more it may be out of reach for some families because it requires a high level of expertise. Can therapy that is not up to standard be more harmful than no intervention? That's an it depends question, because it depends on how bad the other therapy is. You know, if you've got somebody diagnosing sex abuse with a Ouija board, yeah, that's pretty awful. On the other hand, these skills are teachable. There is a great deal that we did that lots of people have done. I run supervision groups here. These skills are teachable, especially for the team that's working with the kids. Like if you have one high-level family therapist, but you have somebody working with the kid who's less experienced or working with each parent, and the higher level person does some teaching and coordinating, even a highly trained ICL can do that, then by the time you're done, you've got 5 competent people. Let me show you how that works. I don't have to get to all the cartoons, but can we go to the next slide real quickly? Sally, come back if I haven't answered your question. So a lot of modern therapy right now, can we have the next slide, please? A lot of modern therapy
it's just
right
stuck.
now. It's stuck? Okay. So the things that we need to, if we get it back working, let's go to the first cartoon. What we need to really focus on is what messages are the kids taking about how they should cope with life, what they can do about problems, what skills they need to have. The kids that we have in our cases need to learn to say, I need, I want, I hurt, I think. They need to be able to differentiate their own feelings from other people's feelings. They need to be able to know that they can cope with life, that there are skills and resources available to them. Am I allowed to take control here or no?
I'd love you to be able to take control. It's just, I'm just not able to move on or back.
Glenys, are you able to, there you go.
Go next.
Here we go.
And next. Okay, so one of the things that we want to focus on is who's willing to solve the problem, who isn't willing to solve the problem. What are the practicalities? Can you as an ICL, with the assistance of a mental health professional, prescribe, get an order for such precise procedures in parenting transitions that anybody can follow them if they're willing to do so? Can a therapist be brought in to focus on what the coping skills are? Remember that new evidence-based or evidence-informed therapy young therapists are graduating with the skills to do some of these things, to do EMDR, cognitively focused trauma therapy. Let's go on to the next one. So I'm going to look real quickly as to what are the results? What do we want? Is this the kid we want to grow up? Is this what we want when they're done? Because a kid like that could end up in the juvenile criminal system, right? Because they need to learn that everybody has to follow rules. It's a new spin on the kid doesn't want to, so we won't do anything. Well, in life, we sometimes have to do things we don't want to do. Next one, please. So you think about this now, we see this in so many cases, right? We see it from parents, of course, because the partnership has split up. But do we want a child growing up this way? Do we want them internalizing anger for the rest of their lives? Bringing that attitude to anybody who vaguely reminds them of this, having the cortisol levels increase so that they're vulnerable to diseases later. There are lots of cognitive control and trauma control therapies that lots of therapists, if they don't know them, are capable of knowing them. And I've done longer trainings in Australia. I can't do all of this in an hour, but these skills are teachable. Next, please. Okay, similar message, different cartoon. When I started in practice in the 80s or early 80s, we really sent kids out into the world with a V for victim on their forehead and not much else. But that's not the universe we live in now. We live in a universe with evidence-based and often short-term trauma therapies. And Australia has some great resources for some of that. Next, please. There's another one we all get. If I'm not comfortable, I shouldn't have to do it. Here's the kid who would never graduate from kindergarten. We can help kids make themselves comfortable. We can find out what they're uncomfortable about. Are they worried that a parent will yell at them on the way home from therapy? Are they worried that, if they say hello like a polite kid would do to any adult, some terrible reaction will follow, that they'll be disloyal to the other parent? What are they worried about? In no other part of life do we stop just because the kid says they're uncomfortable. We always ask what's making them uncomfortable and whether we can help, right? This kid is not a healthy kid. Next one. Another dysfunctional reaction that we get. Next. Or can we teach kids to believe they have lots of feelings and that that's okay and they can handle their feelings? Next, please. That they can use their words, a really important one if a kid is going to be in danger. I'm not dissing people who use all play therapy or Santre therapy or whatever, but most kids are not going to get help based on what they make in sound. They need to learn to use their words. Next, please. Next, please. This is a big one for our cases, right? Can we get a parent to give the kid permission to have fun with the other parent? Next. There's another one because we have some kids who don't think they can do anything that's hard. You do hard things and be proud you did them. Next one, please. When I get scared or nervous, I can. Australia, I think, has a free site for downloading something similar to the Calm app. The kids can use to calm themselves down. Doesn't even require a parent. Next, please. Next, please. Again, this is normalizing the message that we're giving kids. What's the message we want them to take away? Next, please. Next, please. There's another one I use with kids. Let's make a contract that if a parent says something that's distressing, the kid can stop the conversation. Some of these kids I give magic words to, and they will use like earthquake or something with a literal connotation of an explosion. But the deal is, if they do that, the parent has to stop and bring it into therapy. Next, please. Next, please. I don't know if there we go. It is working. This is the subject of a longer presentation, but we do need to have a solution set, especially with court orders, that make sense. are integrated. Next, please. I know I'm running out of time. This is also the subject of a longer training. Sometimes what we need to do is to reverse the way we commonly think about things. Lawyers, and especially the court, they want to just think about timeshare, when to the kid, having some rules so that mom and dad will behave themselves on the sideline at the football game or not be at the football game at the same time is more important to them than counting up the number of hours. And the more we get specific, the more we know which parent is going to work with us. Next one, please. Okay, so here's our book. I owe it to my co-authors and our great contributors to show you a picture of it and tell you that I think in your handouts, there's a coupon from the publisher. And then the final one, this is me. The QR code, I've never done one of those before. Thank my wonderful assistant, Kaylee. The QR code apparently will take you to my website. There's an article section there. The articles that I have permission to distribute, you can download from there. And again, the newer ones, I'm going to try to get permission from AFCC to give to you. I know we're just about out of time. Are there any last minute questions, comments, jokes? So are we at time, guys?
Yes, we're perfectly on time. Is just going to have a look at, now that I'm not screen sharing, I can see the chat. Is there anything in the chat? Any comments that people would like? Lena, you know, from me, I'm so pleased that you've talked about getting the terminology right. Alienation is one of those terms that we hear in our mediations. And I'm really confused about it. Also, I was interested in your term concept creep. And I haven't heard that term before, and I'd like to know more about that. And also, you jumped over toxic stress.
I will try to get you something. But concept creep, I can't take credit for that. It was actually invented by a guy named Haslam, and he was trying to apply it to, in some cases, definitions of trauma, in some cases, definitions of harassment. And he made the argument that if one expands a concept, you can expand the concept to have more compassion, say, for a hostile workplace. But if you expand it so far that everything becomes a hostile workplace, then it's hard to get help for people who've been severely victimized. It applies really well, I think, to things in our field. It's a great example of a concept creep is what's happened with the alienation discussion. There's no question that there are some parents who severely undermine the relationship with the other kids, with the kid and the other parent. Sometimes those are the violent parents. And I'm lovely. Shanna said that the term parental alienation cannot be used in the Hong Kong family court. Here in Brisbane, many judges hate it. Thank goodness. What a lovely piece of news. It's going out of session in California as well. But in some cases, due to some movie star involvement and such here, it's become, we're not just going to outlaw that term, we're going to outlaw all information on children's suggestibility. Everything a child says is absolutely true. Nursery school teachers know that's ridiculous, but we're going to outlaw any language that could possibly indicate that the child is being exposed to conflict by their parents and what the impacts of them are. So it gets ridiculous at the other end as well. Something like, Mike Saney did a study, something like 80% of us are in that magical middle. There's only a few people who are insisting on categorizing those of us in the middle as being on an extreme. And I think those people are really hurting kids, no matter what extreme they're on. Mary Gleason asks, Are you suggesting that we should have referrals to family therapy that might be more directive of the therapist? The answer to that is sort of yes. You have in your material a model teaching order that it's a teaching order in that it's not for a specific case. I modify that for the different cases that I have. The family law court in Perth adapted my order years ago to some of their cases. And so, yes, we want to be able to say to the therapist, this is the purpose of the referral. These are the goals that we want the kid to meet. The therapist has to have some discretion to say there's something awful going on here that I have to address. I will say in defense of the DV community that obviously sometimes domestic violence dynamics get missed, but in my experience, the answer was never to ban therapy because it is the therapists who sometimes see that a parent who engages in coercive control, sometimes they can't help themselves. And so they come into therapy claiming they're innocent and the court didn't sustain it. And then they start trying to control the therapy in a way that sort of lets it all hang out. What's going on? Let's it all hang out. That's terrible. It's an American idiom, which means they hang themselves. So anything else, guys? Thank you all for the kind words.
Lynn, just another quick question from me. We do, as mediators in our family law mediations, have to be really cautious with the language that we use. And language can certainly trigger parents in a mediation. Language like coercive control, alienation, domestic violence. And often it might come from the other parent who is saying that this is being perpetrated by a parent who may be triggered by these. Any tips for the mediators in the room for dealing with parents who might be triggered by these terms that we so loosely use and specifically use in our mediations when someone is triggered by them?
Well, you're all up against the Huffington Post, right? I mean, we've all got we didn't have time to deal with that tonight, but we're all up against the parent who read the description of these terms online, right? And they've got their one-page description of whatever it is. And so we have non-professional sources of information coming in. We as parents, I mean, as professionals, guardians, like our clients often act like children, right? But we as professionals can, in the way that parents model for children, we can model the use of the correct terminology. So we can say, I know that's a really triggering term because people use it inaccurately sometimes. So I'm going to ask you, instead of giving me a label, I want to know specifically what the other parent did or what it is that you think they're doing. And and what, because many times, let's say the kid's crying at a transition and the other parent is holding a child who's perfectly capable of walking. And what we do sometimes then is what Linda and I did was to give instructions that were incredibly specific. The child will be required by mom to walk toward dad's car. Mom will walk the child down and say, have a good time with daddy. Mom will then turn around and walk away. Or let's say the dad's picking the kid up at school. Mom will not volunteer at school on that day. And then if the kid is engaging in those behaviors anyway, we can start looking at other things. We can also look at whether a parent who's not cooperative is willing to do that. Same thing with the accused parent. We're going to expect them to exhibit some self-control and not say to the kid every time they're upset about something that it must be the other parent who talked them into it. It's sort of like if what the parent's being accused of is not happening, then the parent should be able to engage in healthy solutions to protect the child from conflict. But we have to set a model. We have to say to people like the Shana, I don't know how to pronounce his name, sorry, said that the term parental alienation cannot be used in the Hong Kong family court. I love that. We should be talking about parent-child contact problems and what the possible contributors are. And you're welcome to use our models of that, where we listed a lot of the things that can be going on, but we should be using terms that let people know that there's a huge range.
Okay, that's helpful. Thank you. Thank you, Lynn. So I can now see the chat page. I can't see anything else in the chat. So if no one else has any comments, questions, or chats that they would like to add, Lynn, I would just like to thank you so very much for staying up tonight, for sharing your knowledge, your expertise. It's been wonderful. And I know it's been a long day for you and you've had a big week. So I am going to stop the meeting now. Thank you again.
I'm so sorry to interrupt you, but I forgot to ask this. Can I ask a favor of everyone here? The AFCC has, in fact, as you remembered to say, but I didn't, reconstituted the task force for court-involved therapists, for the guidelines for court-involved therapists. If you're not familiar with those, look at them because they can already probably help you. But you will have a survey that will go around, that will be on the professional listservs. I'll make sure Judge Altobelli distributes it to you all. Take a few minutes and answer the questions. Tell us what's good about the guidelines, what's bad about the guidelines, what you would like us to do as we modify them, because your input is fantastic. I'm sorry to interrupt you, Glennis. I'd forgotten that.
Not a problem.
Ask for help.
Lynn, thank you so much. And yes, we also have some interstate guests today from other parts of Australia, Lynn, who have joined us. So thank you for your participation and your interest in attending. Lynn, thank you very much for an amazing presentation. And thanks to Kelly, who's been assisting you. She's been a great help. I'll be in touch, but in the meantime, I'm going to let you go, get some rest. And folks, I'm going to close down this session.
Bye, everyone.
Thank you
so
Lynn.
much.
Thank you.